My name is Barton Morris. I'm the principal attorney at the Cannabis Legal Group. This is Cannabis Live. I'm recording from my office here in Royal Oak. We provide legal services to cannabis businesses seeking to get licensed in the state of Michigan through the Marijuana Regulatory Agency and different municipalities throughout the state. This episode is about the top reasons why an applicant gets denied through the Marijuana Regulatory Agency for pre-qualification. What that means is, in order to be able to get a license for a cannabis business, the company or the entity that we create has to be pre-qualified through the Marijuana Regulatory Agency. In order to be pre-qualified, all of the individuals that have an ownership interest in the company or the license or the entity in which that we're supposed to get licensed, all the owners have to be given background checks. Their criminal background history, their financial history, regulatory compliance history, a number of things, and including their spouses, are looked at in order to pre-qualify the company. So anybody that has over a 10% interest has to disclose. So sometimes, if somebody has a prohibitive criminal history, and for a lot of other different reasons that I'll explain in a second, they will get denied, and that becomes very problematic. So not only am I going to talk about those top reasons, but I'll also talk about the things that we can do to fix it. I also talk about the things that don't work, because a lot of companies, a lot of people will try to do things in order to try to avoid these requirements, and they just simply don't work. So I'll talk about that as well. The top reasons why that people get denied. The biggest reason, I think, and by the way, our company, we in almost every case have gotten all of our applications granted. I think we've only had one get denied, and that one's it's being appealed right now. So we have over 95% of our applications are granted. But I have had experience with many people who get denied, and they come here and asking us to appeal their decisions, which we do as well. And I see, just being in the industry, understand what's the reason why people get denied. And the top reason, the reason that people get denied by the Marijuana Regulatory Agency for pre-qualification is their failure to disclose everything, particularly their criminal history. If somebody forgets to include, you have to disclose all of your criminal history. Every person that has to disclose everything, you got to disclose everything. Not only your conviction history, your arrest history, any interaction with the police, all of these things have to be disclosed. One of the things that we do is perform not only our own background check, but we'll also communicate with local courts in an effort to try to ensure that we are getting everything in order to disclose it. And even offenses that are not likely going to cause any type of problem, if you forget to disclose it, that's a big problem. The MRA in their application section, they will deny an application if, let's say, a DUI that was received while somebody was in college, or even a minor offense was received a long time ago, sometimes 10, 20, 30 years ago, and we forget to disclose it. Well, they don't take kindly to that. They will deny your application. So, and it's not just criminal offenses, but like civil litigation history, bankruptcies. Failure to disclose everything on the application results in a large number of denials. And the other thing that they require is a disclosure of people's regulatory compliance history. And what that means is many people are licensed by the state of Michigan or by another state in order to conduct some other type of business. That could be in the casino industry, or even just in the real estate industry, the liquor industry. It could be in a professional licensing, like as an attorney, a doctor, even cutting hair. You have to have a barber's license. So we have to disclose these things. But not only do we have to disclose the license, but we also have to disclose any regulatory non-compliance history. If there has been a documented, and particularly a repeated non-compliance history, if somebody in their professional licensing has demonstration that they are just not able to follow the rules, that's another reason why people get denied. And I'd say the other significant thing would be tax deficiencies or financial issues. When individuals are perhaps making cash deposits in their bank accounts, demonstrating that they are not necessarily reporting this revenue to their tax returns and not paying their taxes. That's another issue that MRA doesn't like, understandably so. Or tax deficiencies, where there's been litigation or there's been any type of issue with either the IRS or the Department of Treasury, and they are assessing tax penalties or tax deficiencies. Those are problems. Those are illustrated problems. So there's a whole list of things that people get denied for, and then it comes to the situation of, well, should somebody actually file when they know they have these issues? Should they file and then put the company in jeopardy? Or two, if they do get denied, what can happen? So oftentimes, I'd say more often than not, people know that they're going to have an issue, right? So I'd say more often than it happens where people know, like they don't know they're going to get denied, they know they're going to have a problem, right? So what do people try to do? Like, so for instance, if there's somebody that has a felony that involves theft or dishonesty within the past 10 years, they know that they're not going to be able to be licensed, but they want to be in the industry and they want to be part of the company. And then what do they do? Well, I've seen lots of situations where they will create side deals, right? Like, we're talking about contractual agreements that the parties have made in order to make that individual that wouldn't be qualified to somehow preserve their equitable share in the company. And oftentimes they're written, sometimes they're not, sometimes they're on a handshake, but the fact of the matter is that they're against the rules. And if the Marijuana Regulatory Agency were to find out about it, then that is going to cause a significant problem for a licensed entity. So my advice here is just simply don't do it. And I've seen this happen, and it's not pretty. What will happen is that let's say two partners, they want to be 50-50 partners in a cannabis company that's licensed by the Marijuana Regulatory Agency, and so then they, because they know one of the partners is not going to be able to get licensed, they will submit an operating agreement, which is the agreement that must be created for limited liability companies, that lists and that it delineates who the members are. They have to submit that to the Marijuana Regulatory Agency, and in this case, perhaps maybe we have two partners here, but the one partner that can qualify, he submits it in his name only, and then these two partners have this side written agreement that says, okay, well, partner A is really going to be the one that's on the license, but partner B is going to try to hide his membership interests, and they create some other document. Well, guess what? Now we have two competing documents. One of them that's been disclosed, one that's not been disclosed, and of course, not disclosing all documents is against the rules, and if the MRA were to find out, they're going to probably take that license away. So the question then becomes, well, what about this second document? Is it even enforceable? I mean, what let's say that partner B is not getting what they think they deserve, and partner A, they have a disagreement. So what is partner B going to do? File a lawsuit perhaps and try to allege that this second document is the real document? Well, that's going to cause a problem in a lot of different ways. One way is that we have now two competing documents that are going to be litigated in court. Which one do we know? How do we know which one's the right one? Secondly, causing a lawsuit against the company that has been, and individuals that are members of the company that are licensed, they have an obligation to report that lawsuit immediately to the MRA. If that is done, then the MRA is going to know that there is this side secret agreement, which when they find out, that's going to cause a revocation of the license. Now, let's say that the partner A and the licensed entity chooses not to report this lawsuit. Well, they're going to be out of compliance at that point, and when they renew their license, this lawsuit's going to come up, and that's going to cause an issue of regulatory infraction as well, which also could cause and probably will cause a loss of the license, certainly a hefty penalty depending upon the circumstances. And so really this second agreement, even though it makes partner B feel good and perhaps partner A feel good, it's really they're setting themselves up for failure, because it can't really be enforced in court, and it's just going to cause a problem, a regulatory infraction for the licensed entity. So what in the alternative can be done? And there are a lot of things actually that can be done. For instance, first of all, remember that a partner B can always have a 10% or less stake in the company and not have to be pre-qualified or not have to go through the disclosure process. Of course, that may not be how they want their interest to be represented, but this is the maximum amount of interest that they're permitted to have without disclosure, and so that's something that's better than nothing. Secondly, they can have an interest in other fashion. For instance, with the real estate, it's completely legal for partner B to simply then be an owner of the real estate have a membership interest in the real estate that is leasing to the licensed entity, because of course all marijuana businesses and licenses are have to be attached to some real estate. And so if there is an ownership interest in the real estate, they can still participate and perhaps even be an employee, but not a managerial employee, and participate in the operation of the business and derive their income or interest through the leases of the real estate. And the leases cannot be it can't be tied to the income. They can't say, well, our lease is going to be 45% of what type of revenue or of the net profit of the company. Of course, that really is just an end around and making them an equity member of the actual licensed entity. That's not going to work either. It has to be an arm's length transaction, and it has to be a legitimate lease. But that is a way for partner B, somebody that can't be licensed, to be included and to maintain their interest. Another thing that we do, if we have a question as to whether partner B can get licensed, is that we move forward with only partner A, get that entity licensed, and then add partner. First of all, do what we can to fix the circumstances for the reasons why we believe that partner B may not be able to get licensed. We either take care of the tax deficiencies or make sure that we are make sure we're disclosing everything. Whatever the issues are, we try to take care of them. In the example of the felony, if there's a felony within, let's say less than 10 years old, then perhaps we just have to wait until the felony is expired. Whatever the case is, we can get the licensed entity licensed and then attempt to add partner B later, and then try to perfect their interests as originally intended to do it later. That way we get it licensed, we get it in operation, add the partner, and attempt to add the partner B, and if it works, then great. If it doesn't, then at least we're not jeopardizing the progress of the company and its ability to be able to get licensed. Another thing that we can do is partner B can, especially if they're wanting to loan money, right? Their capital investment or the capital contribution, that capital contribution will be in the form of a debt instead of equity. And we can create agreements that will convert that debt into equity upon approval of the marijuana regulatory agency. So if partner B was introducing X number of dollars into the business, we'll just characterize it as debt until the MRA approves that equitable interest at a later time. And when that happens, then it can be converted to equity, and then that equity can even relate back to the origin of the application and the license in an effort to try to preserve the equitable share of partner B. These are things that are completely legal. I'm not suggesting anything that's unlawful, that's up against the rules. The most important thing is that we follow the rules and that we do things the way that the MRA wants them to be done. There are ways around it instead of trying to be shady and trying to have side deals or secret deals that end up never working. This is what we do here. One of the things that we do. We have to exercise some creativity and understand the legalities of the circumstance so that we can assist our clients to get what they want while still remaining within the rules. Ultimately, I think that any person that is a legitimate business owner, they should have the opportunity to participate in the market. If they're legitimate, if they don't have this history of non-compliance, and even if they do, people change. Just if somebody has a history of non-compliance in their past, it doesn't mean that they're always going to be non-compliant. So we will fight for them. We will do what we can to suggest ways that will make things work. And I think in almost every case, we've been able to do so. So that's my advice for today. I am grateful to be providing it and to be servicing the cannabis industry. Look forward to additional videos that we will continue to be putting out and provide the industry with our legal analysis and our legal services with the Cannabis Legal Group. Thank you very much.